Next up, we will look at what's called an Upjohn warning. Now, I'm taking a little bit of liberties with the plot line here, but this is the third season where Harvey's client, Ava Hessington, who is an executive of this oil company, is accused of murder. And there is, meanwhile, some sort of hostile takeover going on. So thought this was a good example as any to talk about what's called an Upjohn warning. Let's watch a clip first.
Not a bride, plain as day. That's exactly what it is.
Tony Giannotti's got a hold of that video somehow. I think he's trying to take over the company.
You son of a bitch. You leaked it.
Ava Hessington is Hessington Oil.
Not for long.
Excuse me?
This is my home.
So when a company like Hessington Oil, for example, is conducting an internal investigation, right? Let's say Harvey in Suits is going in and investigating as the lawyer for the company. Again, I'm taking little liberties with the plot here. But if a company is doing an internal investigation for their client, the company, and an executive is charged with murder, for example, the lawyer owes a duty to his client, right, not to the executive, if his client is indeed the company. And let's say the lawyer goes in and interviews various employees as part of this internal investigation. In doing that, the lawyer will give what is called an Upjohn warning. It comes from a Supreme Court case called Upjohn versus United States. And it's basically like a Miranda warning for the corporate world. And the company's lawyer will inform the employee that the lawyer only represents the company and not the employee individually. Among other things, this Upjohn warning will warn the employee that while the attorney-client privilege will protect the communications between the company's lawyer and the company's employee, the company ultimately controls that privilege. That means that if the company decided to waive the privilege and then reveal what that employee told the company's lawyer to a third party, let's say the Department of Justice, that is the lawyer's prerogative or the company's prerogative, right? So, for example, let's say an employee of this oil company in Suits knew something about Ava Hessington's involvement in this alleged murder for hire scheme, and then the employee told the company's lawyer about it. While that would be privileged information, the lawyer could have a duty to go and tell the board of directors of the company about it. Or to use a slightly different example, if the executive was committing an ongoing crime or fraudulent scheme, the board might even be obligated to go tell the authorities of that because there are, again, limits to the attorney-client privilege. The attorney-client privilege, while it would cover something like a crime that happened in the past, if there is something that's ongoing, we call that the crime fraud exception. And the lawyer may even have an obligation to tell the board of directors, at least, of that ongoing fraud. If it's, again, the lawyer represents the company, the lawyer's duty is to the company. So, again, to recap, the Upjohn warning is one sort of limit to attorney-client privilege in the sense that the privilege only protects so far as the company decides to keep it, and not between the employee and the lawyer for the company. And then secondly, there is a exception to the attorney-client privilege for crime fraud.